Hello, we're here today to discuss our recent article, No Right to Cancel, No Right to Costs. I'm Paul Wainwright, Head of Technical Cost Disputes at BLM Law. The regulations that we referred to within the article are the Cancellation of Contract Regulations 2008. These are a set of regulations that are designed to protect consumers from rogue doorstep sellers, but the unintended consequence of the regulations is that it affects all contracts made in the home during the relevant period of the Act. This includes CFAs and other types of retainers such as credit hire agreements. Compliance with the regulations is fairly straightforward. If a contract is made in the home, then the contract must contain a relevant cancellation notice. This can be incorporated within the document itself or in an additional cross-reference document.
I'm Andrew Coyne and I was instructed to act on behalf of the defendant by Ecclesiastical Insurance Group. Upon receipt of the claimant's bill of costs, the personal attendance upon the claimant was dated on the same date as the CFA as advised within the Notice of Funding. As such, I asked for disclosure of the CFA and the supporting documentation to allow us to see whether or not the regulations are being complied with. Upon receipt of the documentation and review, it became apparent that the regulations had not been applied with, and therefore there was an argument that the contract was unenforceable. This argument was pleaded within the defendant's case, and the matter proceeded to the first detailed assessment hearing.
At the first detailed assessment hearing before District Judge Britton, who's the regional cost judge in Bristol, the claimant solicitors disclosed two witness statements, one from the claimant solicitor and one from the claimant themselves. The witness statements essentially said that there was no intention to create legal relations, as the claimant solicitor, prior to signing the CFA, informed the claimant that he may have BT insurance and this needed to be investigated. Once this was investigated, the claimant's argument was that then the retainer became effective and the contract was made. District Judge Britton heard submissions from both the defendant and claimant on this point. The claimant's point was that there was no intention to create legal relations, and without that there could not be a contract, and therefore the cancellation regulations did not apply. The defendant's position was straightforward. The contract was clear and unequivocal on its face, and using the objective evidence available, the contract was made at the date it was said to have been made in the claimant's home. The claimant submitted that the decision of District Judge Britton was a mixed finding of fact and law, and District Judge Britton applied his mind correctly to the subjective test of whether a contract was made at the time it was said to have been made. Having heard both sets of submissions, His Honour Judge Denier found in favour of the defendant and stated that the contract was made at the date at which it was signed in the claimant's home. As a consequence, the cancellation regulations applied, and as a further consequence of the claimant's solicitor's CFA not incorporating a cancellation notice, the retainer was unenforceable between solicitor and client. The net result of this was that the indemnity principle applied and no costs incurred under the CFA were recoverable.
In a fairly wide-ranging judgment, Lord Justice Underhill upheld that the contract could not have been entered into at any other time other than the date that the initial attendance took place at the claimant's home. As such, he confirmed that the regulations would encapsulate a solicitor as being a trader, and the claimant in this matter would be dealt with as a consumer. As such, the regulations would apply, and therefore the contract was unenforceable against both the claimant and the defendant. In a summary, at the end of the judgment, Lord Justice Longmore confirmed that the indemnity principle was still in effect and would apply to this matter. This decision and the regulations will affect contracts which were entered into in the claimant's home between the 1st of October 2008 and the 13th of June 2014. As this is over a period of around 6 years, there are likely hundreds of thousands of retainers which have been caught by its provisions. There is a strict application of these regulations, and therefore failure to comply with the regulations, as in this case, could result in a fatally unenforceable contract.
So what does Cox versus Woodlands Manor Care Home show us? Well, it shows us two things. The first thing is that it shows the benefit of a detailed and forensic review of the circumstances surrounding the entry of the claimant into the retainer with their solicitor. This review needs to be undertaken by someone with the relevant experience to understand the 2008 regulations and apply them in practice. The second thing it shows us is that the indemnity principle is alive and well. Despite Lord Justice Jackson recommending its abolition in the 2009 final report, we are no nearer this step.